and a warm welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner eDiscovery today, called Important eDiscovery Case Law Decisions for July 2024. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. Questions will be answered during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Kaylee Wallstad, EDRM's Chief Strategy Officer, is here. Please tell us what resources are available today, Kaylee.
Perfect. And I always look forward to these entertaining and educational monthly discussions with such a great group. We are loving on 24 with so many more ways for you, our audience, to engage. If you check out your console to the right of your screen, you'll see the question mark icon. This is where you can type in your questions for today's faculty, and we highly encourage you to engage and do so. You'll also see the slides icon. Slides will be made available after the webinar has concluded. The paperclip icon is for related content. And if you click on it, you'll see today's resources carefully curated just for you. The On24 engagement tools descriptions for you to download to help you better engage with the platform. There's a link to click to subscribe to eDiscovery today and never miss a thing. It is my favorite way to start the day. There's also a link to learn more about the Honorable Judge Peck and how you can engage with him. And a link to order your copy of Tom O'Connor's spicy book, eDiscovery for the Rest of Us, recently updated in a collaboration with EDRM's trusted partner NextPoint. Be sure to get your copy. And then save your seat. Click the link for next month's Case Law Edition on August 22nd. And up next on EDRM's webinar channel, July 25th, Discover It All with Venio. Be sure to save your seat for that enlightening product showcase. Speaker bios can be clicked and popped up to learn more about today's faculty. And then just like Zoom, I saw somebody had already clicked emojis. Thank you for that. If you click on the smiley face emoji, you'll see many more reactions that you can click to today's webinar. And we highly encourage you to engage with them. We're having a lot of fun with them on this platform. And then the Twitter bird is for social media. You can see the links to follow EDRM and eDiscovery today on LinkedIn. And back to you, Mary.
Thanks, Kaylee. So our speakers and faculty today, Doug Austin is the founder and editor of EDRM Trusted Partner eDiscovery Today. He's an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times and has a little bit of a celebration he'll clue us into a little bit later. Tom O'Connor, affectionately known as Tom O, is the director of the Gulf Coast Legal Technology Center. He is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters where he's worked with firms of all sizes, including the plaintiffs in the BP litigation. He's been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And as Kaylee said, his most recent edition of his spicy popular book, eDiscovery for the Rest of Us, it was launched at Legal Week with EDRM's trusted partner NextPoint. And the Honorable Judge Andrew Peck is a Band 1 Chambers ranked senior counsel at DLA Piper, congratulations again, where he advises on copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first and most significant eDiscovery opinions. EDRM is grateful to all three gentlemen for their service on the EDRM Global Advisory Council. And without further ado, Doug, is there something going on today that's special?
There is, Mary. Thanks for mentioning that, and we will get to that in a moment. But obviously, you all are here for some cases, and so we will get into those as well. It's great to be here with you all today. In fact, after last week, it's great to be anywhere. So we do have 6 cases to discuss this month, and those cases address disputes related to discovery about discovery, requests for forensic examination of devices, production of highly technical files, unsupervised collection of ESI, the attorney's role in discovery delays, and a relief request for a pre-suit deposition order. As a reminder, we do welcome questions, and we'll try to get to as many as we can, and we'll send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Disclaimers are like hurricanes, you just can't stop them. And don't get me started. Before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Trigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 36,800 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. Now, as Mary mentioned, one more thing. Last month, we teased a birthday, and this month we're celebrating it. This webinar began 4 years ago this month, and as you can see, we've discussed a whopping 267 case law rulings since then, including this month. We've got warmed up in 2020 and then kicked it into gear after that. So certainly we thank all of you for tuning in each month. We really appreciate it. And I think it's safe to say that nobody is covering as many cases as we are month in and month out. So, and I want to thank certainly all my colleagues, Mary, Tom, and Judge Peck, for being great participants and providing their expertise all these 4 years. So, with that said, let's get into the cases. Our first case, which was suggested by Judge Peck, illustrates what we see in a lot of cases, multiple discovery disputes. Here, Massachusetts Magistrate Judge Donald Capel ruled on several discovery requests from the plaintiffs in a motion to compel, including interrogatories number 9 through 11, where he found that the defendants adequately responded to interrogatories 9 and 10, but found that the response to interrogatory number 11 was insufficient. So he ordered the defendants to further supplement their response by identifying any devices from which documents concerning cynosure were deleted after their employment ended. Next, he addressed interrogatory responses referencing Rule 33D, where he found that the defendants' supplemental responses, which removed references to Rule 33D and incorporated narrative forms, to be adequate. He also did not order the translation of Hebrew language documents, stating, "The First Circuit has previously ruled that the Federal Rules of Civil Procedure do not give the district court any authority to order a party that produces foreign language documents in discovery to translate those documents into English at its own expense. Instead, the plaintiffs may seek reimbursement of their translation costs from the defendants should they prevail at trial." There was also a dispute over defendants' production of a redaction log, where Judge Capel stated, "The defendants represent that they produced redaction logs on April 11, 2024. While the court credits this representation, it notes that there is no corroborating information in the declaration that the defendants filed in support of their opposition. Nonetheless, the court, based on the defendants' representations, denies the motion to compel as moot with respect to the redaction log issue." Judge Capel also denied the request to reopen the deposition of defendant's 30B6 witness, but instead ordered defendants to provide answers to 8 questions related to production parameters, including search terms and date ranges. Finally, he declined to award attorney fee sanctions, citing reasonable arguments from both sides on various issues. There are a couple of other issues he ruled on as well, which you can check out in the case. So, Tom, do you think the court should have required more than just the defendant's representation that they produced a redaction log, given that they didn't mention it in their declaration?
I mean, it's a head scratcher, right? I mean, he says the motion to compel is moot, and usually that word means, you know, something happened that made the whole thing irrelevant. So I don't know if, and I went and looked at the underlying decision. You know, I pulled up the full report, and it's pretty much the same wording that you copied out there. You have up there on the screen. So right. I don't know if they said something in a hearing, if it was mislabeled and maybe was attached someplace else, or maybe the judge is just saying the equivalent of I'm taking their word for it for now and let the other party, you know, bring some sort of an additional motion if that turns out to be not true. It would seem foolhardy to say to the court we filed it and be so specific about the date, right. and then not have filed it. That would be treading with Rule 1.1, right?
Sure. Yeah.
So,
yeah, it does. Yeah, it does. That seem.
There's something else happened here, I think, that maybe just isn't reflected in the written record.
That's always possible, certainly. Yeah, and at least they gave a specific date. We didn't see any indication from the plaintiffs that they were saying they weren't produced on that date. So yeah. I guess we can go with that. So
let me just chime in, and that is. What is and it's on this topic, but off topic. What is the point of a redaction log for privileged redacted documents?
I was wondering about that myself. Yes, actually.
The privilege log is generally for a document that hasn't been produced at all. And you want to know who wrote it, who received it, how many other people received it, what type document, blah, blah, blah. Typically, in a well-done redacted document, all of that is apparent from the face of the document. And in the middle of the document, a sentence or two, or heaven forbid more, is redacted, in the redaction block says redacted privilege or redacted attorney-client privilege. What's the point of logging that? I scratch my head when I see that, and we do see it quite often.
In 2600, right? It's not like 50.
Right. Yeah, that's a great point. Yeah, I was wondering about that myself. So certainly they did one in this case, and apparently that was enough for the court. So Judge Peck, I'm going to ask you about another decision from Judge Cabell. What do you agree with Judge Cabell's decision to identify questions for the defendants to answer instead of reopening the 30B6 deposition?
In this case, yes. I don't think that would work in every 30B6 situation, but here, the unanswered questions, the instruction not to answer questions was Bookbinder's phone searched? That's sort of a yes or no. And then otherwise, what searches were done? What were the search terms? What were the dates of when searches were done? And what was the from and to scope on the dates? And that's information most likely to be held by counsel. And you don't want counsel to be your 30B6 witness. And you don't want counsel to have to prepare the witness on it. So yeah, having the equivalent of interrogatories to provide that information seemed like a reasonable way to handle it.
Yeah, makes sense. So another dispute, Mary, was a dispute about the original use of Rule 33D in responding to interrogatories. So what is Rule 33D, and when is it appropriate and not appropriate to use for interrogatory response?
Well, this is a good one. This is an option to produce business records, and you have to specify the records that must be reviewed in sufficient detail to enable the interrogating party to locate and identify them as readily as the responding party could. And they have a burden test in there that if the burden of deriving or ascertaining the answer will be substantially the same for either party, then the responding party can, give this option. It reminds me a bit of quick peeks or, a request to inspect records that usually people don't like. They don't like the other side mucking around in their, in their systems. So I would think a trade secret litigation would be a terrible case to do this with. I mean, certainly trade secrets include things like customer lists. Business records have customer lists, in their invoicing system. So I think it's something to be very very careful with.
Yeah, maybe why we don't see it as much that often. So
the other point in practice is many times the lawyers will say, under 33D, the answer to this interrogatory can be derived from the documents we're producing. Period. Nice and specific, vague in the extreme. What the rule technically requires is for you to say, the answer to this can be found in the documents we're producing, those that bear Bates stamps number 1, 5, 22, etc. So it's documents you probably had to produce anyway, and then specifically point to them instead of having to write a narrative. But it's abused a lot.
Certainly sounds like it. So interesting, and certainly we see cases like this all the time with multiple disputes. So we thought we'd kind of cover one here that illustrates that. And we'll move on to our next. Oh,
sorry,
yeah, go ahead.
Doug, one last point. Just note the translation issue, and I point to it only because, parties nowadays might think, oh, let's go use Google Translate or whatever. And as we know from the AI world, you got to be careful if you're putting confidential client material into outside tools. Are you making that information open to the public in some unknown way?
Yeah, absolutely. Great point. Consider a translation tool or service you have control over, for sure. So great advice. Now we'll move on to the next case, which was also suggested by Judge Peck. And here, the defendant collected documents in response to plaintiff discovery requests, including one from the Suncrest employees it hired, Dustin Della, with whom plaintiff alleged defendant conspired to steal plaintiff's trade secrets, and Brian Easterly, defendant's chief banking officer. Third-party subpoenas of those same employees identified additional documents not produced, including emails Della sent to Easterly from his personal email address. After meeting and conferring, defendant indicated that it was in the process of reviewing and producing additional documents, and its investigation revealed that there were approximately 20 emails between Della and Easterly that Easterly deleted pursuant to his standard personal email practices and prior to defendant receiving plaintiff's demand letter and the filing of the complaint. Plaintiff requested a forensic inspection of Easterly's computer, and the parties also met and conferred about that, but failed to agree on it. Defendant stated it would export Easterly's data from its spanning backup platform to determine what documents were not collected and reviewed, run the search on those documents, and produce all responsive documents not already produced. Ultimately, plaintiff represented that defendant made an additional production of approximately 20,000 documents, which include emails between Della and Easterly, but more because plaintiff added more customer names to the search parameters. Defendant contended the motion for a forensic inspection was not ripe, but California Magistrate Judge Sherry Pym disagreed, stating a party may also move to compel a forensic examination as a remedy without serving a standalone discovery request when such request is to remedy or sanction a failure to comply with discovery obligations. As such, plaintiff's request for forensic examination of Easterly devices is right. But she also stated, plaintiff fails to make a showing that any evidence was destroyed or missing. Plaintiff's argument rests on defendant's incomplete initial production, Easterly's deletion of responsive emails, and Easterly's general practice of deleting emails. After some investigation, defendant informed plaintiff that some of those documents had indeed been produced, and Easterly, in accordance with his personal email practices, had deleted approximately 20 emails before the filing of the complaint or the March 22, 2022 demand letter. Defendant subsequently produced the emails identified in the January 5 letter to plaintiff. Thus, the documents identified by plaintiff in this motion were not destroyed. Plaintiff has not identified documents that were destroyed and merely speculates Easterly deleted relevant other emails, and these emails were not preserved in other custodians' emails and produced. Mere speculation of destroyed documents is an insufficient basis to grant a motion to compel a forensic examination. Citing defendant's continuous cooperation with plaintiff, she declined to order that forensic examination. So Judge Peck, in light of the fact that Della and Easterly communicated via personal email accounts and Easterly deleted some emails, do you agree with the decision not to order the forensic examination?
I do. It appears, first of all, that certain of the deletions were made before there was a duty to preserve the pre-litigation, pre-notification, et cetera. So that's not something that could be akin to spoliation. But most importantly, the evidence, at least as recited by the court, is that most of the lost emails were produced from other custodians or backup sources. So there really is no loss. And on a, call it proportionality principle, call it you don't have to be perfect principle, what was done was sufficient. And a little practice point note, just as in the In Re Pork case, this was a situation where the plaintiff subpoenaed not only the opposing party, but sent subpoenas out to the former employees. So it was the old belt and suspenders. If I can't get it from the entity, I'll get it from the employees.
Yeah, great point. And one of the reasons they were able to identify those emails that weren't produced. So Mary, Judge Pym cited mere speculation of destroyed documents as not a sufficient basis to compel a forensic examination. But having proven that documents were deleted, shouldn't that be good enough? I mean, you can't prove what isn't there.
Well, it didn't really even have to prove that documents were deleted. I mean, I think they told them that they were deleted before the obligation to retain was there.
Yeah,
they also had that spanning backup. And if I took a look at that, and that's pretty impressive. It does Microsoft 365 as well as Google Docs and Salesforce, all backed up in the cloud. So that was nice. I also think that they cooperated and were not, they weren't irritating to the judge in a way that 1.1 would come down on their head. In my experience, when forensics are ordered, usually there's other bad behavior, and I think that they got through on this one.
Sure. Continuous, like Judge Pym stated, continuous cooperation with plaintiff might have been the Rule 1.1, the antidote to Rule 1.1. So certainly, Tom, the defendant dealt with several discovery issues, and they had to make a supplemental production. So what recommendations do you have for our audience on how to avoid potential sanctions or orders from the court when you do make mistakes?
Well, I think this case is a good example of how to do that, as you and Mary both pointed out, that they were cooperative with the other side. There was no equivocation or trying to get around it. You know, mistakes happen. Sometimes you don't get stuff. And up in the very first paragraph you had there on the slide, I saw, you know, right in the middle there was a nice little statement that after a meet and confer, the defendants began reviewing and producing additional documents. So they sat down with the other side and talked about it and discussed some ways that they could deal with the issue. I think that's the way to handle it. There's a mistake, you say there's a mistake, and then you sit down with the other side and say, what can we do to get, you know, to get those documents? And if we have to go to other custodians, great. You know, their cooperation, I think, went a long way towards obviating any need on the court's part for sanctions.
Yeah, I agree. A lot of our cases are examples of what not to do. This is a really good example of what to do. And the defendant did a great job of being very cooperative and addressing their mistakes. For sure. So we'll move on to the next case where we're going to get a little technical. Like the first case, there were several disputes, but in this case, we're going to focus on just one, as we sometimes do, as particularly instructive. So here, the plaintiff asked the court to compel the defendant to produce pure native files of all documents it previously produced in unreadable and unusable form. The plaintiff argued the defendant failed to produce the pure native technical files in a form or forms in which it is ordinarily maintained or in a reasonably usable form or forms per FRCP Rule 34B2E2. Plaintiff explained that technical files such as S37 or hex files, as opposed to common files such as Word, PDF, or Excel, can only be opened using specific technical software programs. eDiscovery programs like Relativity are not equipped to open or present such technical files. Therefore, they're typically produced in pure native form, meaning not through eDiscovery programs such as Relativity. This is because the individual files are part of groups of files called projects that need to be opened simultaneously using certain software programs, and if they are processed through Relativity, the organizational structure is lost and the files can't be opened or viewed in the appropriate software programs. Despite knowing these files cannot be opened through Relativity or any other eDiscovery platform for that matter, defendant processed and produced the files through Relativity. Defendant claimed that it already produced these technical files as it kept them in the ordinary course of business, arguing that its production was consistent with Rule 34 because it produced these documents in native format, provided the metadata that permitted the plaintiff to recreate the folder structure of the production, and identified the software needed to view these file types. It also raised the issue that the supporting attorney declarations lacked foundation because of lack of expertise, and the plaintiff hadn't retained an expert. California Magistrate Judge Autumn Spaeth stated, DT's position is uncompelling. There is no question that these technical files are relevant. DT does not contest EMC's assertion that technical files are typically produced in pure native format. DT likewise does not contest EMC's assertion that the organizational structure of these technical files was stripped or changed by DT processing and producing them through Relativity. Indeed, testimony from DT's own eDiscovery specialist indicates the organizational structure for these technical files has been altered. Finally, DT fails altogether to address EMC's assertion that sending the technical files in pure native form would be quick and easy. Rather, DT misconstrues EMC's request and provides no real explanation for why it refuses to simply provide EMC the pure native technical files. At the hearing, DT failed to articulate any undue burden. DT attests to producing native technical files processed through Relativity and to providing EMC with metadata to allow it to recreate the file's organizational structure. The court understands this to mean DT has not produced the technical files in pure native form, but that doing so would be a little burden. So she ordered the defendant to reproduce those files. So Mary, the defendant produced the files, provided the metadata that permitted plaintiff to recreate the folder structure of the production, and identified the software needed to view those file types. Why wasn't that enough?
Well, I think you hit it on the head. They gave them metadata that would allow them to create, they'd have to create a program to make that file structure. They'd need to make the file structure so a piece of proprietary software more than likely would be able to read it, who knows what configuration files would be necessary. And when we produce native files, many times we rename them so it has like a virtual Bates number in the file name, and that would never work. And we saw this with PSTs, with parties requesting emails in PST format, and the emails would be reviewed in a regular, eDiscovery platform, and then the toothpaste would be put back in the tube, basically. Take those MSGs and stuff them into a PST format, and undoubtedly some of the metadata would change. The metadata for today's date, for example, the relative file path, because nothing's going to be exactly the same system to system for file paths. So so I don't think it was enough. And if they could just reproduce that without passing, without giving them highly confidential or privileged or other material that should be held back, they should have just done that.
Sure. Yeah, that's a great analogy. And definitely, I remember some of those cases where parties asked for PST files to be produced, and it was problematic, which is probably why we don't see too much of that anymore. So great point. So, Tom, we'd like to thank eDiscovery platforms like Relativity can handle any file type, but some aren't conducive to analysis. Some file types aren't conducive to analysis and review in eDiscovery programs. So what do you recommend for identifying those types of files and handling them in Discovery?
Well, identify them early. This one was also kind of a head scratcher to me because the plaintiffs seemed to have identified that and said, just give us the native files, and the defendants were adamant on, we're going to run it through Relativity and then give it to you. And we are repeating, we are giving you software or native files, and we did give you native files. I suspect that what they did was take the native file viewer in Relativity and do an export from there, which is it's not the same as the original native files. As they said, you have to take the metadata and reconstruct the file structure. What was really troubling about this was like, what's the big deal? I don't know why they couldn't just agree upon this by discussing it early. Even the judge said there's no great burden. The judge said it was actually a little burden to produce the native files. Sometimes it's just because, technically speaking, people only know how to do things one way. And so they're used to dumping stuff into Relativity, working in Relativity themselves internally, and when you ask for documents, dumping them out. And when you ask, and I've had a fairly large case with a proprietary software database with exactly that, where the internal technical staff at the corporation simply didn't know how to do it. They had only been trained how to do things one way, and that's what they knew. So, I mean, poster child for what the meet and confer is designed to do, right?
Yeah, absolutely. No, that's a great point, because that's one of the things I liked about this case is that, there are all types of files out there that are involved in Discovery, and not all of them fit into the cookie cutter of an eDiscovery platform. So yep. It's great to kind of understand that you've got to have special accommodations for certain files in certain cases. So Judge Peck, what do you make of the defendant's argument that the plaintiff had retained an expert to help it review defendant's production, including those technical files? Should Judge Spaeth have given that argument more weight?
Nope.
All right.
I will expand. In some cases, failure to have an expert, failure to understand what the problem is, can be held against the requesting party. Here, the plaintiff knew what it needed. It just wasn't getting it. It's sort of like the old days where a party took a spreadsheet or something and turned it into a PDF and therefore not, destroyed all the formulas. there are certain things that have to be produced the way they're kept and not further processed. This is not a case where the plaintiff didn't understand the file structure. It just needed the material to be produced in that file structure friendly manner. So expert, not to deprive Tom and his brethren of work, this is not a case where an expert was appropriate. And indeed, I do wonder whether defendant just didn't know what it was doing or was trying to burden the plaintiff, but it's sort of like, I'm not sure why this ever made it in front of the judge.
Sure. No, it does seem, I mean, and obviously these were files that were important to the case. So,
you know what our old friend Browning Moran used to say, never attribute to malice what can be attributed to incompetence.
True. Yeah. Good point. And that's, we don't know which one applies here, but got a question and a comment from the audience. The comment, with regards to DT's production of native files through relativity, I think the unanswered question is whether the produced files were sufficient to load into the specified software or not. In my opinion, the original production may have been enough. Well, certainly the plaintiffs didn't think so, while the defendants said it was. So the judge, I think, had to make the ruling based on what she saw there. And then a question.
And if
so
I
what
could
do you
interject there, Doug, I think just quickly, it wasn't the files, it was the structure.
Right.
It was how the files interconnected. Yeah.
Right. Exactly. And it's kind of like I think the judge, said, well, they could try to piece it together, or you could just give it to them the way that's going to be most useful. So it seemed like the appropriate ruling there. Question from the audience. So what do you recommend as best practice? Zip the top level folder and produce with a slip sheet? Well, it's, you're kind of, I guess that's kind of what you're doing. I don't know specifics on how these files are structured, but certainly the folder structure and what have you is key to this. So perhaps so. Tom, Mary, any thoughts on that?
Well, I think the key is, do you have something that's going to read those files if you get the native files? Asking for native files is one thing, being able to open them up is another. So if they just if they recreate the folder structure and give you the native files, sure, no problem.
Sure. Yeah. Well, and that's obviously, like you said, Tom, stuff to discuss in the meet and confer. They should have probably said, hey, we're going to expect certain files like this. Let's come up with an approach for them instead of dealing with it on the back end. So great comment and question, and we'll move on to our next case, which was suggested by Judge Peck. And in it, the plaintiff sought an order compelling defendant DVG to produce additional financial documents associated with the sale of its products, and a witness prepared to discuss same, and compelling DVG's counsel, rather than defendant each Ilavici. Man, I practice this name a lot. I have to say it about 10 more times too, so bear with me. To search his email, cell phone, and Amazon portal and produce all responsive documents, among other requests. In denying the plaintiff's first request, Florida Magistrate Judge Lisette Reed stated, ZAG argues that Mr. Ilavici was entirely unprepared for the deposition. The court disagrees. Mr. Ilavici was deposed for over 4 hours and spent 20 to 30 hours preparing for the deposition. He explained key details associated with the financial documents, including the source of the sales data and the method of calculating the net profit. Simply stating that he would have to look into certain topics does not indicate a complete lack of preparation, as ZAG argues. She also rejected complaints about deficiencies in the sales information for the relevant period, noting each Ilavici's declaration, which stated that he was willing to provide updated sales information. In granting the plaintiff's second request, Judge Reed stated each Ilavici testified that he did not provide his attorneys access to the Amazon Seller Central account and signaled uncertainty as to the terms used to search for responsive documents. Mr. Ichilavici confirmed that business with vendors is done in person, over the phone, and via text message. However, no text messages or a log containing details regarding these text messages were produced. ZAG also points to responsive emails between DVG and Amazon associated with publicly available reviews, which it argues were also never produced. The relevant rules and case law establish that an attorney has a duty and obligation to have knowledge of, supervise, or counsel the client's discovery, search, collection, and production. It is clear to the court that an attorney cannot abandon his professional and ethical duties imposed by the applicable rules and case law and permit an interested party or person to self-collect discovery without any attorney advice, supervision, or knowledge of the process utilized. Clearly, counsel for DVG should have supervised its clients in the collection of VSI. Mr. Ichilavici is both an individual defendant and the representative of DVG, bolstering the need for a thorough document search by DVG's counsel. As such, DVG's counsel is ordered to review DVG and Mr. Ichilavici's records and produce any documents responsive to ZAG's discovery requests, which were made prior to the close of discovery. Should counsel for DVG discover any non-produced responsive documents, the parties are directed to confer and set a reasonable timeline for that production. So, Tom, we still see a lot of cases involving court rulings about unsupervised self-collection. Why do you think we see so many cases, and are there cases where unsupervised self-collection should be okay?
Well, to your first point, or your first question, why are we seeing so many? I think there's a couple of reasons. One, clients think they can do it easily in many cases. Two, they think that because there's a ton of people out there advising on ways to do it. So you can read, even see webinars on self-collection and tools that are available. And so it's kind of like, well, I'm not going to spend all that money on a forensics guy if I can do this myself, which is unfortunate. And then three, part of that is that many vendors, apps, software companies, provide self-collection tools of varying degrees of accuracy and promote them. So, people are getting hit with a lot of, you can build this battleship in your living room. So they do.
I think you're forgetting number 4 on your list.
Yeah.
Lawyers uncomfortable doing it, and so they're perfectly happy for their client to do it on their own.
Great point. Lawyers aren't easily stepping into that void and saying, hey, bad idea. Which kind of comes into your second question. Are there cases where this should be okay? Well, certainly not a court to Judge Reed, right? In that jurisdiction, he was pretty clear, and I think it's great advice. The attorneys have to give some sort of advice, supervision, or at least have knowledge of the process utilized. So even if they're not doing the collection, they've got to be able to look at it and say it meets muster. Judge Peck is right, though. Many, if not most of them, don't feel up to that task. So it just kind of leads to this perfect storm of things that lead to self-collection being so prevalent.
Sure. Well, maybe that's why they need a geek to help them, because sometimes that's the answer to make sure that the attorney's on top of things. But
a geek a week, that's all we ask.
A geek a week. That's right. Judge Peck said, "Bring your geek to court when you need to." So there you go.
It says that my friends gave me.
That's awesome. I might have to get me one of those. So Judge Peck, unlike some cases we've covered, Judge Reed chose to wait on ruling on the plaintiff's attorney's fees and costs request until after discovery. Do you agree with that? And should defendant's counsel be responsible for at least some of those fees and costs for not being more involved in collection?
Sometimes having to deal with cost motions becomes a sideshow. It gets the parties even more angry at each other and makes it harder to cooperate. So that's one reason to possibly defer it. Of course, from a selfish point of view from the judge, another reason is By the time we get to the end of the case may settle and I won't have to decide it. But, I would prefer in most cases that the cost decision is made at the time of the motion for sanctions in order to both send a message to other cases and even in the particular case, let the party whose conduct is not up to snuff know that there is a price to pay for misconduct. Now, should the lawyer pay it as opposed to the client? Hard to tell from this opinion all the facts necessary for that. Sometimes joint and several responsibility, and then you could collect from either the client or the lawyer. In some cases, the client will step up and reimburse their lawyer. But you need more information than there is in the published opinion here to know whether the lawyer was really at fault. Maybe the client said, I can't afford to have you do this. I know what I'm doing. I am directing you to leave me alone. We're going to do this internally. Don't know.
Right. No, that's, fair point. So Mary, this is the second case we've discussed today where there was a difference of opinion as to whether the witness was prepared to testify. So what recommendations do you have for our audience to prepare a deposition witness, especially if they're a 30v6 witness?
Well, first you have to assess the person for deposition or testimony. Are they believable? Do they have enough confidence? Are they too much or too little forthcoming? And then do they know too little and then you need to prep them a lot? Or do they know too much and then you need to sort of back them down from what they know? Because you certainly don't want them to answer questions that you don't want in the record. And then using documents that are already produced to, get them familiar with them, have them ask questions about, what do column headings mean and things so that they can represent well within the bounds of the claims and defenses, the interrogatories, the requests for production, all the filings and things like that. And so that it's believable and they don't feel like you've put somebody up there that doesn't know what they're talking about just to, obfuscate.
Yeah, absolutely. No, that's those are great points. A comment from the audience: self-collection would be safe if supported by a vetted process which supports custodians in their collection and the collection is vetted afterwards. Just leaving a custodian without support is always dangerous. Couldn't agree more, and a vetted process is definitely, it doesn't necessarily mean that the attorney has to be right over the shoulder saying, yeah, okay, collect this, collect that, but a process that is vetted, like Hans said here, and what the attorney can be aware of and understand that process, certainly I think is what the judge would have been looking for here. So interesting case, and we'll move on to our next case. Which is a case where we learned that it's not always better to ask for forgiveness than permission. Here the parties submitted a joint written discovery report and a supplemental JWDR, but those both failed to comply with the court's case management procedures, so the parties were directed to meet, confer, and further report on their discovery disputes in a compliant JWDR. Parties did so, and therefore plaintiff was granted leave to file a motion to compel, which he did, but defendant didn't file a response. The court resolved plaintiff's motion to compel largely in his favor, and defendants were directed to take 9 specific actions toward compliance and discovery. Subsequently, plaintiff filed a motion for sanctions under FRCP Rule 37, claiming that defendants failed to comply with 8 of the 9 directives from the court's discovery order, requesting several sanctions. So why didn't defendants respond to the motion to compel? Because counsel for the defendants felt it was justified. Defendant's attorney also cited the monumental task of timely responding and that defendants complied with all discovery issues by May 3rd, among other things. Also, although defendants' compliance did not occur within 10 days as required, defendants requested a finding that their supplemental responses were timely due to good cause and excusable neglect under Federal Rule of Civil Procedure 6B. Illinois District Judge David Dugan stated, Now, the court must impress upon its parties its belief that these discovery disputes, which do not present any unusual degree of difficulty, have been ongoing for far too long. After all, the parties failed to make use of the court's case management procedures, which ordinarily facilitate the resolution of discovery disputes by experienced counsel without the court's intervention or handholding on routine and non-complex matters. Defendants ignored the timeline that was clearly set forth in the court's discovery order, and according to plaintiff's reply, still have failed to satisfy their discovery obligations. To be clear, the untimeliness was a choice by defendants. They did not seek an extension of the time to comply with the discovery order, which the court likely would have freely given. Instead, they now seek a finding of good cause and excusable neglect under Rule 6b. In other words, as the old adage goes, defendants choose to seek forgiveness rather than permission. This was a miscalculation. The court cannot ignore that defendants' dithering has now resulted in both a stall of discovery and disobedience at some level that may still need to be determined of the court's discovery order. Again, plaintiff alleges, even setting defendants' untimeliness aside, the supplemental responses remain non-compliant with their discovery obligations. So Judge Dugan ordered defendants' attorney to pay fees and expenses and warned the parties again to use the court's case management procedures to address discovery disputes or potentially face sanctions. So Judge Peck failing to comply with the court's case management procedures seems like a surefire way to invoke your Rule 1.1, and it seemed to do that for Judge Dugan as he mentioned them at least 3 times. Did you have any specific case management procedures that you wanted parties to follow?
Generally, all of my procedures should be followed. My direction to parties in front of me was to bring possible discovery disputes to me promptly. Meet and confer first, but bring the disputes promptly so it doesn't destroy the schedule, so it doesn't linger. And in cases where I thought they needed this, I would have monthly status conferences just to let them know somebody was watching what they were doing. And generally, it's amazing how, the day before the scheduled conference, they got a lot of things done and resolved. So, but, when a court says, I'm ordering you to do 9 things, that's an order. It's not a suggestion. It's not a, if you please do this, please. So yeah, it's a clear violation of Rule 1.1 here, which is, for those who may have missed me describing 1.1, unwritten rule, don't piss off the court.
There we go. And this one certainly seems to have done that based on Judge Dugan's statements about his case management procedures. So, Mary, are you surprised that the defendant's attorney was ordered to pay the expenses and fees instead of the defendant itself?
Well, I was until I read that timeliness thing, that it was one of the core issues or responding to something, the things that, a represented party's counsel would be expected to do and responsible for. It didn't seem like it was a lack of cooperation, that the party wanted them to, take a hard line or anything like that. It seemed to be just, bad lawyering.
Yeah, it certainly did. And maybe this falls into that. We'll see. Tom, what do you make of the defendants not responding to the motion to compel because counsel for the defendants felt it was justified? Even if you agree with the other side's motion, shouldn't you provide some sort of response?
Shouldn't you not say that in a pleading? I mean, come on, man. This is like worthy of ESPN on Sunday football. You said what? Come on, man. Yeah, bad lawyering. I think Mary just covered it. Bad lawyering. I mean, I'm gonna say something, and at least I'm gonna say what it is I'm doing. They had stated at some point, I think there was a quote there, they continued to work in an effort to respond to the untimely, to the outstanding discovery, but it was a monumental task. Well, say that to the court. The judge said, I would have granted an extension. I would have freely granted an extension, right? So say that to the court. and as you alluded at the beginning, it's the judge said it's the old adage: defendants choose to seek forgiveness rather than permission. This was a miscalculation.
Yeah, yeah. My favorite line of the case for sure, and maybe a good kind of maybe a good proviso there. Except in court, maybe it's better to ask forgiveness than permission. That's
I also like the next sentence where he said he referred to what they were doing as dithering.
Yes, I like that too. So, all right, we'll move on.
Go ahead. Never a good sign when the judge says, and the all caps in that last sentence on the slide, that warned was not Doug being fancy or sticking his finger too long on the all cap button. That was the judge.
That was the judge.
When you're being warned in all caps, you know the judge is not happy with you.
Yeah.
Indeed. Yes. No, great point. Yes. 1.1 definitely was crossed in this case. And now we'll go to our last case, which is unique because it's not really a case. No case actually has been filed, or at least it had been as of this ruling. In this Texas state case suggested by Judge Peck, Aaron Ralph sought a pre-suit deposition under Texas Rule of Civil Procedure 202 to investigate a potential product liability claim related to injuries she sustained during sinus surgery. The surgery involved a Clarence navigation balloon dilation system, which uses artificial intelligence for navigation. Ralph's petition requested broad discovery, including documents related to the NBDS, and she argued that this discovery was necessary to decide whether to file a product liability lawsuit, emphasizing the potential burden and expense of such lawsuits. McLaren opposed the petition, arguing that Ralph had sufficient evidence to file her lawsuit and that her discovery requests were overbroad. The trial court held a hearing at which counsel from both sides presented argument, and actually the trial court granted Ralph's petition, compelling McLaren to submit to a deposition and produce documents. McLaren filed a mandamus petition contending that the trial court abused its discretion in granting the Rule 202 petition, and the appeals court agreed with McLaren, ruling that Ralph failed to provide sufficient evidence to justify the pre-suit deposition and that the trial court's decision was an abuse of discretion. Reasons included that Ralph's petition did not adequately explain why pre-suit discovery from McLaren was necessary, that Ralph failed to prove that the benefit of the pre-suit discovery outweighed the burden or expense to McLaren, that the trial court's decision to grant the pre-suit deposition was arbitrary and unreasonable, lacking reference to guiding principles, and that given that no right of appeal exists from an order allowing a Rule 202 deposition, pre-suit discovery under Rule 202 should be strictly limited and carefully supervised to prevent abuse. So, Mary, are you surprised the trial court ordered a deposition and discovery when a case hadn't even been filed yet?
Oh, absolutely described. And the reason, that they wanted the pre-suit discovery was because lawsuits are just too expensive. Well, discovery is what, 75% of a lawsuit. So I also wasn't surprised, when on appeal it was all slapped down, because you just don't want to see that.
Right. Well, it wasn't her expense. She wasn't worried about it. So maybe that's, yeah, there you go. No problem. Right. So, Tom, are you surprised that Ralph didn't just go ahead and file a case? And if you were working with her, how would you have handled this case?
Well, that was my initial reaction. Well, geez, why don't you just go ahead and file a lawsuit? You're going to get discovery, and move, start discovery right away. File a suit, take a deposition. It's an interesting rule, though, isn't it? This Texas rule that'll let you do this pre-suit deposition to see if there's anything there. I mean, it seems like a fishing expedition, doesn't it? But then, as I read through the whole thing, I thought, well, I guess I wouldn't file a case because the appeals court said Ralph failed to allege any facts or offer any evidence to explain why she's entitled to dispose the corporate representative under Rule 202. So if you don't have enough facts to do that, then you probably didn't have enough facts to file a lawsuit. And I think, as counsel for this client, I would have had a much deeper heart-to-heart about what was there and what was worth pursuing.
Yeah, yeah. And comment here, to me, the Clarent pre-suit discovery was a fishing expedition intended to find grounds for a case, e.g. looking for a potential flaw which can be exploited. This suggests to me that Ralph had no idea what the grounds for the suit were at all. And that could be, yes, certainly does seem like a fishing expedition. So, Judge Peck, certainly it's unusual for discovery to be ordered before a case is even filed. Are there circumstances where it can be justified?
Well, Texas has this rule, so there must be some situation that falls under it. In the federal rules, I can't think of anything. The closest, factual thing I can think of is where you have a plaintiff on, death's doorstep or something, and so you bring a lawsuit against whoever the defendant is going to be, and you ask for an expedited self-deposition of the client to preserve their testimony. But again, there's a lawsuit there. You're just moving up some part of discovery. The other thing, and we'll see if you guys remember this, in the early days of eDiscovery, when the issue was the trigger for preservation, some scholars or purported scholars were suggesting that there should be the ability to bring some sort of lawsuit or petition in front of the court to get the scope of preservation clarified before there was the full-blown lawsuit. And generally everyone said, no, can't do that.
Yeah. So Texas has a bad power grid and a funky rule about pre-suit depositions. So what can I say? It's my state, and here we go. But yeah, very interesting. I thought it was an unusual case when you suggested it, Judge Peck, and certainly we don't cover that many state cases, and this was an interesting one. So certainly a fun one to end. And we are past the top of the hour, so I'll move to our contacts page and our next case law webinar as the dog days of summer continue, as you see there. As Kaylee mentioned at the top of the hour, is on Thursday, August 22nd. So certainly want to thank all of you for attending. And with that, I'll also say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. And I'll turn it back over to you, Mary.
And before you do, happy anniversary, Doug.
Happy anniversary, Doug.
Happy anniversary. It's for all of us, yes.
Yeah, happy anniversary. And Doug, thank you for anchoring these 4 years, and Tom O'Connor and the Honorable Judge Peck coming all 4 years for all this insightful presentation and others. Our thanks to the EDRM community for your kind attention in all of them. And if you really loved it, show Judge Peck, Tom O, and Doug Austin from Houston some love. Find those emojis at the bottom of your console. And to be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks, folks.
Bye, all.